calendar as a whole.
We still have a quorum.
Or
We still have a quorum meeting. We get.
Yeah. we got-
right, or you remove 18 and he votes on the rest.
Okay.
I'll wait for the staff to give me the go ahead on starting.
He can vote.
Working on it right now.
Okay.
Pardon?
Working on it right now.
Oh, that's fine. No, I knew that. So should we take 18 off and do it separately or just?
So it's only a potential conflict, so he can vote. He's made his conflict disclosure.
Thank you. I overheard part of that. Thank you.
On this side on here. Yeah. Maybe. This is the one I'm looking at right here.
Yeah.
Oh, yeah. Okay.
In every time.
Absolutely. Wait till it starts thinking for itself. I'm really in trouble.
Skynet.
We've seen that movie. It's not end well.
No, it's not a-
Oh,
Yeah.
that's funny.
We were, don't say we were not warned.
Chair, the room is clear.
Thank you. Let's move forward, colleagues. We will now consider the executive session consent calendar, which involves items on your executive session calendar, items 1 through 18. The first question, does any commissioner want to have an item removed from that consent calendar? Hearing and seeing none, we will now have at least a brief report on this before we ask for a motion. Is this Investigator Fenstermaker or Director Myers or both?
Director Myers.
Thank you.
Well, sorry, Chair, just to be clear, did we end up removing number 18 so that I can vote as to the remaining of the remainder of the consent?
No, Commissioner, you're allowed to vote on the whole thing since your conflict was a potential one, not an
Great.
actual one.
Great,
So you
thank
can
you.
vote. You can vote, and your declaration is on the record previously. So thank you for your question. Director, please.
So Commissioner, Chair and Commissioners, as you know, and as the agenda indicates, these 18 items are on the consent calendar because they were complaints filed for public meetings law violations, where the complainants did not satisfy the mandatory prerequisites of filing a grievance within 30 days. Obviously, quite a number of them are the Portland City Council complaints that have been widely reported. The last 3 were not related to the City Council. They are separate complaints. But as indicated, the complaints did not satisfy the mandatory grievance process, and under 192.685 sub 3, the commission is required to dismiss complaints that do not satisfy that prerequisite.
Thank you, Director. One quick question, friendly one. Can you just remind us in brief what the grievance process is, how it works under law?
Yes, under ORS 192.705, a complainant, a person who wishes to file a complaint regarding public meetings law violations, is required to first file a written grievance with the public body within 30 days of the date of the alleged violation. So if a complaint is that people were on a governing body were texting each other and meeting in private to discuss the governing body's business, the grievance would need to be filed within 30 days of when that texting occurred. Once the written grievance is submitted, they have to give the public body up to 21 days to respond to the written grievance. Only after both steps in the process are completed, written grievance within 30 days, and then a response or at least waiting the 21 days for a response. Only after both steps are completed can they submit a complaint to the ethics. And as I indicated under 685, if they submit a complaint and they didn't complete both of those steps, then the commission's required to dismiss.
I'm
Please.
sorry to interrupt, but, oh, sorry, I thought it was something else. Never mind.
Thank you. The last question, that process you outlined is in fact in state law.
Yes.
So it is, whatever we think of that, it is and whatever anybody thinks of that, that is the state law as currently drafted. Thank you for that.
Correct.
Colleagues, any questions for our executive or others? Hearing and seeing none, Acting Vice Chair Thompson has a motion to make.
Mr. Chair, I hereby move the commission approve the executive session consent calendar as presented.
Thank you. Any questions about the motion that you've just heard? Hearing and seeing none, the administrator will call the roll on the consent calendar for the executive session items 1 through 18.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Chair Fiscom.
Aye.
Motion passed 7-0.
Thank you very much, colleagues. We'll now move following the agenda through the next items in order. The first first consideration for us will be item number 19, where our information indicates that Ashley Martin, an attorney representing the respondent, Catherine Harrington, will be appearing through Teams.
I'm later on right now.
Ms. Martin, if I am saying your name right, can you hear me?
Sorry. You should be over here.
Ms. Martin, can you hear me?
Parsons.
Ashley Martin, you may be muted, *6.
Raised her hand.
She did.
I see your hand up indicating you can hear me. Can we hear you?
Good morning, Commissioners. This is Ashley Martin. I apologize for the technical issue. Is everyone able to hear me now?
Yes, we can. Thank you for being here. For the record, my name is Dave Fiscom, and I'm the chair of the commission. We're going to proceed to hear the item involving the respondent, Catherine Harrington, for whom you're the counsel, right?
Yes, Commissioner.
Okay. Our approach today will be the normal one outlined in communication to you in advance. The first step in our process will be to hear a report from our investigator. So, Investigator Pacheco, please.
Thank you, Chair Fiscom and Commissioners. This is Investigator Daniel Pacheco for the record, presenting executive session agenda item number 19. This is a complaint against Catherine Harrington, Chair of the Board of Directors for Clean Water Services. The complaint in this case alleges that Ms. Harrington used her position on the CWS board to accept unauthorized travel benefits from CWS. In this case, it appears that Ms. Harrington traveled on behalf of CWS on several occasions. Her CWS travel included trips to Copenhagen in 2022, Singapore and Laos in 2023, and New York in 2024. For her trips to Copenhagen and New York, Ms. Harrington purchased her own plane tickets and was reimbursed by CWS. It appears that Ms. Harrington may have earned the personal benefit of frequent flyer rewards when she booked her CWS travel. However, the frequent flyer rewards do not appear to be included in her official compensation package. In fact, it appears that CWS does not have a travel policy applicable to board members nor compensation agreements, and it does not compensate board members directly for their board service. The information also indicates that Ms. Harrington may have used her position to add personal business to her CWS trips. Specifically, she extended her 2022 stay in Copenhagen by 3 days and her 2024 stay in New York by 7 days. Although Ms. Harrington paid for the additional expenses incurred when extending her trips, CWS paid for Ms. Harrington's round trip flights to Copenhagen and New York. Thus, it appears that she may have violated the prohibited use of office and conflict of interest provisions in Oregon government ethics law. Additionally, Ms. Harrington is required to file her annual statement of economic interest. When she filed her 2024 FCI, she reported that she received paid expenses for an office-related event in 2023. However, she failed to include the amount of the expenses she received. While she has already amended her 2024 SEI to include this information, nevertheless, it appears that Ms. Harrington may have filed her 2024 SEI without the required information. Should this case move to investigation, Commission staff would seek to determine whether Ms. Harrington was authorized to be reimbursed for her CWS travel expenses and whether earning personal travel rewards while on CWS business was included in her official compensation package. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Catherine Harrington may have violated the prohibited use of office and conflict of interest provision and SEI provisions of Oregon government ethics law. The recommendation is to move this case to investigation. Thank you.
Investigator, colleagues, any questions for our investigator based on the report you've just heard? At the moment, hearing and seeing none, the time is now, Ms. Martin, for you to make any comments you choose to make to us on the matters involving your client. So please proceed.
Thank you, Commissioner, and I will keep my statement very brief. Initially, as to the allegations involving travel, Chair Harrington followed what CWS's practices that were in place at that time regarding reimbursement. These practices were explained to her when she was elected. She now understands that CWS's personnel policies that were in place at that time only applied to employees, but the agency has recently adopted new policies that are extended to board members. A copy of those policies were provided to the investigator. The personnel policies allow for travel reimbursement and the ability to earn frequent flyer miles by CWS board members. Additionally, the agency asked Chair Harrington to include her frequent flyer miles when booking travel throughout her time as board chair. That was always the agency's practice, and she believed she was following CWS's policy. As the preliminary report found, Chair Harrington only requested travel reimbursement related to the CWS business and did not engage in extravagant dinners, hotel stays, or upgraded airfare. For the travel to Buffalo, she determined the difference in flight costs for the extended stay and only requested reimbursement for the lower cost of the original flight, and she did not seek financial reimbursement for extending her stay and believed she was following policy and practice. Given these past practice and recently adopted personnel policies, we do believe the Commission should either issue a letter of education or dismiss the investigation of these claims further. Just briefly as to the allegation regarding the statement of economic interest filing of April, that was filed in April of 2024, Chair Harrington's submission reported the expenses from the U.S. Water Partnership for the international conference that she attended in June of 2023. In her submission, she included an attachment that showed the exact amount she received from U.S. Water Partnership and all relevant details about the costs. The Commission had the information about the specific dollar amount she received. She believed that was enough to satisfy her filing requirement. She recently learned that there was a field on the SCI filing where she needed to put the dollar amount in order for the public to see it. Chair Harrington did not realize this field was empty and believed the details that were attached to the filing would be public. When she learned of the mistake, she amended her SCI filing to list the amount in the field, and she had no intention of hiding the amount she received, which is evidenced by the attachment to the original filing. It was a simple oversight that was corrected as soon as she learned of the mistakes. Given these facts and the subsequent corrections, we hope the Commission will see that either a letter of education or dismissal would be appropriate next steps. Thank you.
Thank you, Ms. Martin. The time is now to ask Ms. Martin any questions from commissioners. Any questions? Looking for hands. Hearing and seeing none, the time now arises for us to consider as a commission what decision to make on this matter. I'm open to comments from any of my colleagues on how to proceed at this point, based on what you've heard from our investigator and respondent. Hearing and seeing no need for comments. Vice Chair, you ready for our motion?
Sir.
Please proceed.
Mr. Chair, I hereby move that the Commission find there is a substantial objective basis for believing that Catherine Harrington may have violated ORS Chapter 244040 Sub 1, ORS 244060 Sub 5, and ORS 244120 Sub 2, and that the commission should investigate accordingly.
Thank you. You've colleagues heard the motion. Any comments on the motion pending? Hearing and seeing none, the administrator will call the roll on item 19 on our executive session agenda. Please proceed.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Chair Fiscum.
Aye.
Motion passed 7-0.
Thank you. Ms. Martin, thank you for your appearance today. We appreciate your comments. We have now moved forward to an investigation. I'll say something that you may already understand, which is that we have not found there to have been a violation as of yet. We've identified the need for more information, to which end we will now proceed, and our staff will be in contact with you and the respondent. So thank you for appearing this morning.
Thank you, commissioners.
Thank you. Okay, colleagues, we'll now move as soon as we set it up to hear item number 20, one down from 19. And pretty imagine that. Our staff has done right. 20 follows 19. We'll allow our staff to exit and enter.
Don't count on that happening as we get further down the road.
Ready?
We are ready.
Okay, colleagues, the time now comes for us to consider the matters involving Mr. Nafisi Fai, if I'm saying that right. His counsel, Mr. Burke Courageous, if I'm saying that right, has indicated he's appearing by teams. Mr. Courageous, can you hear me?
Yes, I can.
And did I pronounce your name right?
You got sort of close. It's Craigus.
Thank you very much. I appreciate your clarity.
Okay, and also, Ms. Fai is a woman.
I apologize. Thank you
No
for the
problem.
clarification. We'll proceed now as we normally do. The first step in our process, which has been outlined to you in writing, is that we'll hear a report from our investigator, and then we'll proceed through the agenda toward our conclusion. So, Investigator Pacheco, please.
Thank you, Chair Fiscum and Commissioners. This is Investigator Daniel Pacheco for the record, presenting executive session agenda item number 20. This is a complaint against Nafisa Faye, member of the Board of Directors for Clean Water Services. The complaint in this case alleges that Ms. Faye used her position on the CWS board to accept unauthorized travel benefits from CWS. The information in this preliminary review indicates that Ms. Faye traveled on behalf of CWS to attend the 2024 International Water Association Congress in Toronto, Canada. When coordinating her CWS travel, Ms. Faye provided her Alaska Airlines reward number to be added to the ticket to her flight. It appears that Ms. Faye may have earned the personal benefit of frequent flyer rewards. However, frequent flyer rewards do not appear to be included in her official compensation package. In fact, it appears that CWS does not have a travel policy applicable to board members nor compensation agreements, and it does not compensate board members directly for their board service. Should this case move to investigation, Commission staff would seek to determine whether Ms. Faye was authorized to receive reimbursements from CWS and whether her official compensation package allowed her to earn personal travel rewards while traveling on CWS business. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Nafisa Faye may have violated the prohibited use of office and conflict of interest provisions of Oregon government ethics law. The recommendation is to move this case to investigation. Thank you.
Investigator, appreciate it. Any comment, any questions for our investigator based on the report you just heard, colleagues? Hearing and seeing none, counsel, this is your time to make any comments you choose to make to us. Please proceed.
Sure. Well, I'd like to start out by stating that Nafisa Fai is a board member of Clean Water Services by virtue of the fact that she's elected as a Washington County Commissioner. Basically, the way the management of Clean Water Services is set up is that its board consists of the Washington County Commissioners. Ms. Faye did travel to the conference in Toronto on Clean Water Services business, but the entire arrangements were made by the executive management analyst for the CEO of Clean Water Services. Ms. Phi did not make the travel arrangements. They were made by the county or the Clean Water Services staff. It was the Clean Water Services staff member who asked Ms. Fay if she had an Alaska Airlines frequent flyer number. And in response to that request, the frequent flyer number was provided. This was not a request that was initiated by Ms. Phi. I would note the the Washington County travel policy explicitly states that it applies to elected officials and that persons who travel on county business are permitted to retain the benefit of frequent flyer miles on the flights that they travel on. The Clean Water Services policy is ambiguous with regard to the scope of to whom it applies and also with respect to what benefits it covers. But I would note, just given the fact that it was the staff that scheduled the flight and requested the frequent flyer number, that Clean Water Services interprets its travel policy to allow persons who travel on Clean Water Services business to retain the benefit of the of rewards programs and such that it's okay for them to retain the benefits. As I noted, this was something that was initiated by Clean Water Services staff. And I think under the circumstances that further investigation is not warranted and that this matter should be closed. Thank you.
Thank you for your comments, council. Any questions for the council based on the report you've just heard, colleagues? Hearing and seeing none, the time is now for us to move toward a decision on this matter. So I'm looking to see if any of my colleagues have a comment to make on anything they've heard or seen so far. Hearing and seeing none, Vice Chair.
Thank you, Mr. Chair. I hereby move the commission find there is a substantial objective basis for believing that Nafisa Phi may have violated ORS 244-040 sub 1, ORS 244 060 sub 5, and ORS 244-120 sub 2, and that the commission should investigate accordingly.
Thank you. You've heard the motion. One quick question, investigator. I appreciate your earlier reference as to what, if we move forward, what would need to be done. Could you just repeat that quickly for the record?
Yes, thank you for the question, Commissioner Friscom. It would be determine whether Ms. Fay or Phi was authorized to receive reimbursements from CWS and whether her official compensation package allowed her to earn personal travel rewards while traveling on CWS business. Thank you.
Thank you for the clarity of that comment. I appreciate it. Colleagues, you've heard the motion. Any questions on the motion? For the moment, hearing and seeing none, the administrator will call the roll on item 2-0 on our exec session agenda.
Commissioner Thompson.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Jancy.
Aye.
Commissioner Mason.
Aye.
Commissioner McCulley.
Aye.
Commissioner Burke.
Aye.
Chair Fiscom.
Aye.
Motion passed 7-0.
Thank you. Council, thank you for appearing before us today. We appreciate your comments. They were made within the time limit that I didn't even tell you existed. So thank you very much for that and for the clarity of your comments. You understand we now have decided to move ahead to understand the following. We have not found there to be a violation by Ms. Phi or Fay yet. If I'm saying her name improperly, I apologize. We've identified the need for more information. We'll pursue that end. Our staff will be in touch with you and your client. Thank you for your appearance today.
Thank you so much for your consideration. I appreciate it.
Thank you. Okay, colleagues, thank you for that. We'll now move to item 2-1 on your agenda. And we have both the respondent, Pam Treese, and her counsel, Margaret Olney, appearing by teams. Our staff will exit folks and enter folks and give a heads up as to when you're ready.
You're good.
Thank you, colleagues. The time is now arrives for our consideration of on our executive session agenda, item 21 involving the respondent Pam Treese. Our approach will include an opportunity for Ms. Treese as well as her counsel, Margaret Olney, if she's online, to make any comments to us. I just want to check to see if you're online. Ms. Treese, can you hear me? You're on mute right now. *6 will unmute yourself.
I can
She's-
hear you, and thank you for having me join. I believe Ms. Olney will be making a few comments. Thank you.
Thank you very much. We'll wait for that in a minute. Ms. Olney, can you hear me? Is Ms. Olney with us?
She is here on Teams, yes.
Margaret Olney, can you hear me?
Yes, I
So-
can.
Thank you very much. Please, we're going to thank you. We see you now. Thank you for your appearance today. The approach, as I think you know, in writing is going to be for us to consider this item in the following way. First, there'll be a report from our staff. We'll have questions for that, but conceivably we'll turn to you for any comments you choose to make for the record, and we'll get to that in a moment, and then we'll move toward a decision, and we may have questions for you as well. The first step is to hear a report from our investigator. That said, Investigator Pacheco, please, item 21.
Thank you, Chair Fiscum and Commissioners. This is Investigator Pacheco for the record, presenting executive session agenda item number 21. This is a complaint against Pam Treese, member of the Board of Directors for Clean Water Services. The complaint in this case alleges that Ms. Treese used her position on the CWS board to accept unauthorized travel benefits from CWS. In this case, it appears that Pam Treese traveled on behalf of CWS on several occasions. Her travel includes trips to Copenhagen in 2022, Washington, D.C. in 2023, and New Orleans, Toronto, Singapore, and Laos in 2024. It appears that on several occasions, Ms. Treese purchased her own plane tickets and was reimbursed by CWS. It also appears that Ms. Treese may have earned the personal benefit of frequent flyer rewards when she booked her CWS travel. However, the frequent flyer rewards do not appear to be included in her official compensation package. In fact, it appears that CWS does not have a travel policy applicable to board members nor compensation agreements, and it does not compensate board members directly for their board service. It also appears that Ms. Treese may have used her position to add personal business to her CWS trips. Specifically, she extended her 2023 stay in Washington, D.C. and spent several days in New Jersey for personal business. It appears that CWS reimbursed Ms. Treese for her flights as well as a business class Amtrak ticket from New Jersey to Washington, D.C. Ms. Treese also extended her trip to Copenhagen by 2 extra days. Although it appears that Ms. Treese paid for the additional expenses incurred by extending her trips, CWS paid for her round-trip flights to Copenhagen and Washington, D.C. Because it appears she may have avoided financial detriment by receiving benefits not included in her official compensation package, she may have violated the prohibited use of office and conflict of interest provisions of Oregon government ethics law. Should this case move to investigation, Commission staff would need to determine whether Ms. Treese was authorized to be reimbursed for her CWS travel expenses and whether earning personal travel rewards while on CWS business was included in her official compensation package. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Pam Treese may have violated the prohibited use of office and conflict of interest provisions of Oregon government ethics law. The recommendation is to move this case to investigation. Thank you.
Thank you, investigator. Colleagues, the time is now for questions for our investigator based on the report you've just heard. Any questions? Hearing and seeing none, the time is now for Commissioner Treese or your counsel, Margaret Olney, to make any comments you choose to make. Let me just say the following. One, you should choose, you may choose to appear in any order you like. Those, if you're going to make comments, do so by giving your name for the record. And given our long agenda today, I'm going to hold you to a 3-minute time limit for comments you choose to make. So please proceed, whoever wants to. It's up to you. Thank you for being here.
Thank you. I am going to make just a few comments on behalf of Pamela Treese. My name is Margaret Olney Bennett Hartman, and I'm counselor for Commissioner Treese. I apologize in advance. We are having solar installed in our house, so you may hear a little bit of pounding, but I hope you can still hear me. Just briefly, we want to acknowledge that this complaint relates to a high-profile dispute. We understand that and involves an unusual governing structure between Clean Water Services and Washington County. But we believe that the distinction that staff raised between the Clean Water Services and Washington County rules and process is not as significant as staff assert, and that this travel is part of Commissioner Treese's compensation package. First, it just bears emphasis that the only reason Commissioner Treese is a board member for CWS is because she is a Washington County Board Commissioner. It is automatic. It is not anything that is independently sought or pursued. Her primary and default position is a Washington County Commissioner, and therefore she did look to the Washington County Administrative Rules for guidance, as did other commissioners. And in those rules, it is clear that board members are treated as employees per IRS, and therefore they are subject to all of the Washington County travel rules for employees. And those include allowing travel rewards that are incidental as an incidental benefit and part of compensation. That would be paragraph 10.1 of the Washington County rules. In addition, personal travel adjacent to public travel is permitted so long as there's no additional cost, and there was none here. To the extent that there is a separate requirement that there be something specific about CWS, those policies also treat travel awards as compensation for employees. The fact that at the time the policy did not expressly mention board members isn't dispositive. Again, as with Washington County, board members are deemed employees under IRS rules, and there's no reason to assume different rules apply. And to the extent there was any ambiguity, that's been eliminated. Board members are now expressly called out in the Clean Water Services policies, as with Washington County. Finally, I just want to say that to the extent that this the preliminary review and staff suggest that travel was not properly authorized or approved or somehow hidden, there was complete transparency in this case. Travel assignments and plans were discussed by the Washington County Commissioners in advance, planned for on debriefing afterwards. So there is transparency was honored and clearly there. Thank you very much. Those were my brief comments. I'd be happy to answer any questions.
Thank you very much for your presentation, Ms. Olney. Commissioner Treese, any comments you want to add for the record? Feel no need to do so unless it's your choice.
Thank you. I appreciate the comments made by my attorney, and I want to express my appreciation for your consideration in this matter. Thank you.
Thank you. Time is now, colleagues, for questions for our respondents, council and commissioner. If you have a question, I'll look for your hand. Hearing and seeing none, the time now rises to make a decision on this matter before us. I'm looking for comments from colleagues on any matter about what you've just heard, investigator, respondents, paper, etc. Hearing and seeing none, Vice Chair, please.
Sure. I appreciated the council's comment about the ambiguity and the unique government relationship between these two entities. And I think moving this to investigation would be helpful in kind of sorting out how that unique relationship fits in with statutes around ethics. So I'm prepared to move this forward.
Thank you very much. I appreciate your remarks. I associate myself with them without repeating them. Please proceed.
Mr. Chair, I hereby move the commission find there is a substantial objective basis for believing that Pam Treese may have violated ORS 244-040 sub 1, ORS 244-060 sub 5, and ORS 244-120 sub 2, and that the commission should investigate accordingly.
Thank you, colleagues. Any comments on the motion before us? Hearing and seeing none, the administrator will call the roll on item 21, executive session agenda, please.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Jancy.
Aye.
Commissioner Mason.
Aye.
Commissioner McCulley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Chair Fiscom.
Aye.
Motion passed 7-0.
You, Ms. Olney and Ms. Treese, you've heard our decision, which was to move forward to an investigation. Please understand the following. That does not connote or indicate that we have found there to have been a violation. We've underlined by that measure our need for more information. We will work with you to provide that additional information and to clarify issues that have come up before us. So for the moment, I want to thank you for your appearance today and for your patience with our agenda. Our staff will be in touch with you directly. Thank you very much.
And thank you as well.
Okay, colleagues, we'll now move to item 22 on our agenda. Same issues in some respects anyway, involving Mr. Jerry Willie, who is not appearing today. That said, we don't need to admit anybody to the executive session. We have exited the persons as appropriate. So the first step is to hear a report from our investigator. Again, Investigator Pacheco, please.
Thank you, Chair Fiscom and Commissioners. This is Investigator Daniel Pacheco for the record, presenting executive session agenda item number 22. This is a complaint against Jerry Wiley, member of the Board of Directors for Clean Water Services. The complaint in this case alleges that Mr. Wiley used his position on the CWS board to accept unauthorized travel benefits from CWS. The information in this preliminary review indicates that Mr. Wiley traveled on behalf of CWS to attend conferences in Toronto and New Orleans in 2024. It appears that when Mr. Wiley booked his own flights, he included his personal travel flyer number. He was also reimbursed for flights where he earned the personal benefit of frequent flyer rewards. However, frequent flyer rewards do not appear to be included in his official compensation package. In fact, it appears that CWS does not have a travel policy applicable to board members nor compensation agreements, and it does not compensate board members directly for their board service. Should this case move to investigation, Commission staff would need to determine whether Mr. Wiley was authorized to receive reimbursements from CWS and whether his official compensation package allowed him to earn personal travel rewards while traveling on CWS business. Based on the information available, there appears to be a substantial objective basis to believe that Jerry Wiley may have violated the prohibited use of office and conflict of interest provisions of working government ethics law. The recommendation is to move this case to investigation. Thank you.
Investigator, one quick comment for the record. We did receive, after receiving your initial report, another communication from Mr. Wiley. I presume you have not had time, nor could you have had time to review that because it was past the deadline. So that'll be part of your review if this case proceeds. Am I accurate in that regard?
That is correct.
Thank you very much. Colleagues, this is similar to other issues in some respects. You've heard the investigative report. Any questions for our investigator? Mr. Wiley is not appearing today, so the next step is for us to make a decision here, looking to see if there are any hands for comments. And at the moment, hearing and seeing none, Vice Chair, please.
Chair, I hereby move that the commission find there is substantial objective basis for believing that Jerry Wiley may have violated ORS 244-040 sub 1, ORS 244-060 sub 5, and ORS 244-120 sub 2, and that the commission should investigate accordingly.
Thank you. You've heard the motion, colleagues. Any questions on it? Hearing and seeing none, the administrator will call the roll on item 22.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Jancy.
Aye.
Commissioner Mason.
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Chair Fiscom.
Aye.
Motion passed 7-0.
You colleagues, we're going to now move to item 24, skipping one for the moment for reasons of the schedules for a couple of our respondents. We're accommodating that. So our next step will be to consider items involving Jamie Millard, former acting district forester for the Oregon Department of Forestry. So she is going to be appearing by teams, and our staff will do the exit entrance business before we hear this matter before us. Item number 24, colleagues. My page 87.
To the group, and she left for some reason. So
No, we'll give you a few moments to have technology catch up with reality. If she doesn't come back, we can move forward. Otherwise, my information indicates that she did have an 11:30 a.m. appointment, which we were accommodating, so we're very early for that.
Yeah, she just popped back.
She's
up.
back? Good, thank you. So we can proceed to consider that matter straightforwardly if Jamie Millard is back with us. Thank you for working on that.
Should be good to go.
Jamie Millard, can you hear me? You're on mute, *6 to unmute.
I got it. Thank you.
Can you hear me?
Yep, I can hear you good.
Thank you. For the record, my name is Dave Fiscum. I'm the chair of the commission. The time is now set to consider the matter involving you. Our approach, as you may be aware, and what you've received in writing, is to hear first a report from our investigator. To that end, Investigator Fenstermaker, please.
Thank you, Chair Fiscum. Commissioners, I'm Casey Fenstermaker. Agenda item 24 is a preliminary review report regarding Jamie Millard. The complaint in this matter alleges that Jamie Millard misused state assets while an Oregon Department of Forestry employee. Information reviewed during the preliminary review indicates that Jamie Millard used her state vehicle to commute between home and work between February 27th, 2025 and March 28th, 2025 at a cost to the Department of Forestry of $855.50. Use of a state vehicle for personal travel was not authorized pursuant to the Department of Forestry's policies, administrative rules, or Jamie Millard's official compensation package. Based on these actions, it appears that Jamie Millard violated the prohibited use of office statute, which prohibits a public official from using their position for personal financial benefit if that benefit is only available to them because of their position as a public official. Additionally, it appears that Jamie Millard failed to disclose a conflict of interest each time that she used the state vehicle for personal use. As a result, the preliminary review report in your meeting books recommends moving this case to investigation.
Thank you. Any questions for our investigator based on what you just heard, colleagues? Hearing and seeing none, Ms. Millard, welcome to this process today. The time is now for you to make any comments you choose to make to us. Just two things. If you choose to make comments, please do so for the record by giving your name. And then secondly, I'm going to hold you to a 3-minute time limit because of the length of our agenda today. So that said, please proceed. Thank you for being here.
Thank you for the opportunity. My name is Jamie Renee Millard, and all I want to say is basically what I said in the email too, is that I thought I could take my vehicle to the ODF office here in Sweet Home and drive it to the Molalla office, bypassing the Staten office, as that was okay by my supervisor. I did get lazy a couple of times and I parked it at my house instead of taking it to the ODF office. And saying it out loud, it sounds absolutely ridiculous and dumb and stupid, and that's just dumb of me. I have no it was stupid. And again, I was under the assumption that driving it from Sweet Home to Molalla was an okay thing. When I was the district forester, there were times where I would go to the Molalla office just on the whim. It wasn't a planned thing. A couple of times it was planned. I stopped in Staten at first, and then I was going to go on my way to Molalla. And I thought that was all within the parameters, and it's not, according to everything that's been sent to me and told and read by the DAS vehicle manual. So I apologize for being a complete idiot. And yeah, that's end of my apology, I think.
Thank you, colleagues. Appreciate the clarity of your remarks. I see a hand raised, but first I just want to thank you for being here today and for making your comments and the clarity of them. Commissioner Burke, please.
I would just like to say to Ms. Millard that, you don't have to be so hard on yourself. People people make mistakes. We've all made mistakes in different parts of our lives at different times. And you're being very forthright. You're being very transparent. And I think all of us really appreciate that. So, don't beat yourself up too much. Just learn from the experience and move forward as my personal advice to you.
I appreciate that. Thank you.
Thank you, Commissioner. Any other questions or comments for our witness today? Hearing and seeing none, the time now comes for action on this matter before us. I'm looking for any comments on that score before seeking a motion. Please, Commissioner Thompson.
Question for staff. Is this the kind of situation where the next steps would probably be to offer a letter of education?
Yes, we would run it through the penalty matrix as is required, but it would likely end up in the letter of education.
Appreciate that.
Thank you, Investigator. Ms. Millard, you probably heard that, but without making a final firm commitment, the likely result if we move forward, subject to a motion yet to be made, is for you to receive from us a letter of education, which would be just that, a letter of education on this matter for you. So thank you for the clarity of your comments today. I'm looking for a motion, so I'll turn to the Vice Chair, please.
Mr. Chair, I hereby move that the commission find there's substantial objective basis for believing that Jamie Millard may have violated ORS 244040 sub 1 and ORS 244120 sub 1, and that the commission should investigate accordingly.
You've heard the motion, colleagues. Any questions on it? Hearing and seeing none, the administrator will call the roll on item 2.4 on our executive session agenda. Please proceed.
Commissioner Chansey,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Fiscom.
Aye.
Motion passed 7-0.
Thank you, Ms. Millard. You've heard our discussion on the motion. The motion is to proceed to an investigation. Please understand that we have not found there to have been a violation. The words in our motion are very important. May have. We have not found there to be a violation. We're going to proceed to the next step, which is a likely result of a letter of education for you. Thank you for your appearance today. We appreciate the candor of your remarks, and we hope you have a good weekend. Thank you.
Thank you. You guys too.
Thank
Bye.
you. Okay, colleagues, thank you for that. We'll now move according to my agenda directly. Help me, staff, to item 27. Am I right?
Yes, they are.
Hafner?
Yes, that is correct. Item 27.
This is involving Mr. Richard Slezak and Colleen Verick.
Mr. Slezak is the attorney for Ms. Burek. We're working on getting them online because I know they said that they were going to attend in person, but we were informed they were going to be online. The attorney is here in person. The respondent, we were told, will be online. So
Okay. Yeah, Colleen. Now you can sit at the table, Mr. Slezak, if that's your name. We'll be proceeding in a moment. We want to make sure your client is online.
Judge, I think, Commissioner, I think she is. No, she's just finished her procedure, so I don't know.
We'll try that in just a moment. Thank you for your patience with our agenda.
Oh, you judge. This is getting bad fast. I know. Don't expect me to call you Your Honor. So. Sorry, of course I have.
If you saw our council pledge, there's a reason for that. I'll wait for the heads up. Colleagues?
We have some messages.
Yeah, that's fine.
We're just waiting.
Sure.
we're gonna try calling.
That's fine.
I mean, not us two,
The royal we.
the royal we.
As I understand. The assembled staff elsewhere.
Very long.
Lunch. Ms. Varick is still pending, right?
That is correct. We're working on
Thank
getting
you.
them.
Thank you.
She's joined. She should be joining just now.
Ms. Varick, can you hear me?
No, she's not joined yet.
Oh, okay,
Sorry.
you're just joining. No, that's,
I misled you.
no, that's okay. Okay. Let me know when you think she's online.
Yes. She was here and I activated her mic and then she disappeared. So if another disappearing person, hold on 1 second.
Wait
please.
just a moment. Thank you.
Technology. Is our Brendan?
Again. Okay, we should be good. They'll have to use *6 to unmute.
Ms. Varick, can you hear me?
She's muted still. Yeah, she'll need to use *6 to unmute.
Please use *6 to unmute, Ms. Varick.
Good morning. I am here.
Thank you very much. My name is Dave Fiscum. I'm the chair of the commission. The time is now set to consider the matter on our agenda that involves you as the quote respondent unquote. Mr. Slezak is in the room, and so we'll proceed in the normal fashion. As we consider this preliminary review, our first approach will be to hear a report from our investigator. Then we'll proceed to allow you to make any comments you choose to make to us, as well as your attorney. That said, Investigator Pacheco, please make your report. Thank you.
Thank you, Chair Fiscum and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 27 in your meeting book is a preliminary review report for Colin Burek, Developmental Disability Specialist for Lane Community College. LCC provides training to adults with developmental and intellectual disabilities, known as the S3 program. The complainant in this case alleges the financial exploitation of an LCC student in the S3 program by Ms. Burek, the student's lead supervisor. The Oregon ethics law prohibits a public official from using their official position for financial gain or avoidance of detriment. In this case, the complainant explained that on May 30th, 2025, Ms. Vera contacted the student's on-site lead, stating that she had fallen and demanded that the student go to her home to assist. During this interaction, the student overheard the discussions and left work early to assist Ms. Vera at her home. In this case, it appears Ms. Vera used or attempted to use her position by directing the student's lead to have the student go to her home for the purpose of personal labor. By doing so, it appears Ms. Vera avoided the financial detriment of calling for emergency services and likely the costs associated with insurance copays and deductibles. Thus, it appears she violated the prohibited use of office provision. According to the complainant, Ms. Vera has, on multiple occasions, financially exploited the student by having them do personal labor at her home and working on non-college related tasks. Given the nature of the allegations and information provided by LCC employees, commission staff know that there is need for additional information. Should this case move to investigation, commission staff will seek to determine whether Ms. Burek violated the following provisions in ORS Chapter 244. 040 sub 4 prohibits a public official from using confidential information for personal gain. In this case, when Ms. Burek contacted the student's on-site lead on her personal phone, it is unclear whether that information was publicly available or if Ms. Burek's use of the personal number was gained through the course of or by reason of holding her official position. 025 sub 1 prohibits public officials from receiving gifts in excess of $50 in a calendar year from a source that could reasonably be expected to have a legislative or administrative interest. In this case, LCC staff reported that Ms. Burek had the student do multiple non-college related tasks on her behalf, and it is unclear whether the student was compensated for their personal labor or whether the labor constituted a gift which may have violated the gift clause. Lastly, 120 sub 1 sub C requires a public official, when met with a conflict of interest at each time, to disclose the nature of their conflict in writing to their appointed authority. In this case, it is unclear whether Ms. Burek properly disclosed the nature of her conflicts of interest. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Ms. Burek violated ORS 244.040 sub 1, ORS 244.040 sub 4, ORS 244.025 sub 1, and ORS 244.120 sub 1C. The recommendation in your books is to move this case to investigation. Thank you.
Thank you, investigator. Any questions for our investigator from commissioners? If so, now's the time. For the moment, hearing and seeing none, the time is.
Chair Fiscom, I do have a
Mr.
question.
Jansen, please.
Yeah.
Who's saying that?
Yeah, Peter Jancy.
Oh, Peter, Mr. Jancy, please proceed.
Thank you. My question for the investigator is that the preliminary review report references that it appears that the, what is page 6, it appears the allegations concerning Ms. Burek have been forwarded by LCC to appropriate reporting agencies. And I'd like some more information about the level of confidence that report has been made.
Thank you for the question, Commissioner Jancy. That's all the information I have in terms of that's what was communicated to me. Just in terms of what we do during the preliminary review report is we gather the information relevant to our provisions. And in this case, I did not get any confirmation for when that report was made.
Okay, thank you.
Commissioner, follow up? Make any comments you choose to make. Yeah. Please proceed.
I guess this may be a point of order question, but I think I may have a question that does not pertain to our decision with regards to how to proceed on this preliminary review, but is related to other statutory obligations of the board, and that may be something we need to take up outside the presence of council and the subject.
Executive.
What I would say is I don't know if your question relates to sort of our authority to suspend while other investigations are proceeding. If that's the question, that statute is specific to criminal investigations. Like we have the authority, the commission has the authority, once something's in investigation, to suspend our investigation pending completion of any criminal investigations or prosecutions. I think at this point, we don't know whether any of these other related investigations by LCC or reporting, whether any of those are criminal. That would be something that we would attempt to find out in case we needed to suspend.
Okay. Sure, any follow-up?
No, I think I'm satisfied for the moment. Thank you.
Thank you. Okay, the time is now for our respondents to have a chance to make any comments they choose to make to us. Mr. Slezak, we know you're in the room. Thank you for being here. Your client is online, Ms. Burek. You can please speak in any order that you choose, you and or her. Please do two things. One, when you speak, identify yourself for the record, either one or both of you. And then secondly, I'm going to hold you to a fairly brief 3-minute time slot because of the length of our agenda. So that said, Mr. Slezak or Ms. Burek, please proceed.
Thank you, Commissioner. I will make that 3 limit. My name is Richard Slazak. I'm a lawyer in Salem, and I represent Colin Burek in this proceeding. I tried to, I know, I'm sure you've all read this, besides the preliminary review, the response that Ms. Burek filed in response at this early stage. But so let me see if I can't reduce this to a nugget here. This is an Oregon community college teacher requesting a student's help after a fall does not violate state public ethics laws, provided that the request is a legitimate response to an emergency. Oregon's ethics rules are primarily concerned with preventing the misuse of public office for personal financial gain or inappropriate personal relationships, not with necessary emergency. There are times that a public official engages in, quote, bad behavior that may not be governed by Oregon government ethics laws, including two that come to mind here. One is an isolated instance of poor judgment when administering public money, or being rude or unmannerly. So there are times when a public official is not 24/7 on the clock. And one of the things that I put before you is that Ms. Burek had just been released from the hospital from a medical procedure, and she fell. And she contacted Patricia Robinson about getting some help just to get back on her feet. Now, the official position prohibition is identified in ORS 2440401 that gives an example of times that official position to obtain financial gain would not be a violation of the official prohibition. These are things like there's a variety of actions that a public official may take or participate in that could constitute a prohibited use and not be actionable. This is, for instance, like voting. A position could be voting in a public meeting or placing a signature on a government agency document, making a recommendation, making a purchase with government agency funds, and so on. And this is lifted this from the Oregon Government Ethics Law, a guide for public officials, April 21, at page 17. So there are times when a public official can do something which otherwise generally might be actionable, but under specific limited circumstances would not be. So I put to you that this is an isolated instance of poor judgment, but under the circumstances, it was an action that might be understandable and allowable under Oregon ethics laws. As Ms. Burek had fallen day before Memorial Day weekend, telephoned Patricia Robinson that she needed help to get back on her feet. Ms. Robinson refused to make that request, but the student at issue here overheard on the telephone and left his work site early to go help Ms. Burek get up. True enough, Ms. Burek used her personal cell phone to call Robinson. But in no reasonable way could these actions be considered to have violated the Oregon ethics laws, or he considered to be abusing the student's position with respect to any of the allegations. There's one other thing I want to throw out here.
Please, Zach, I'll encourage you to be.
Minutes, Your Honor.
Okay.
I do want to just.
Please look at and please make one last comment. Thank you.
Sure. No, I will. I'll just sign. The Oregon Government Ethics Commission encourages settlement of a case by stipulated final order. I ask your honors to take this opportunity to follow your own good advice and stipulate the dismissal of the allegations. Find that further investigation is not warranted and dismiss the case. Thank you.
Thank you, sir. Appreciate it. We'll have questions for you in a moment. I want to see if your client, Ms. Burek, has any comments to make beyond what you have made as the counsel. Ms. Colleen Burek, if you can hear me, if I say your name right, you have anything to add?
It's pronounced Colin Burek. I don't have anything to add. I think that it was covered. I would just be reiterating what the attorney has already spoken about.
Thank you for your comment. Appreciate it. Colleagues, any questions for counsel or respondent? Now's the time. For the moment, hearing and seeing none, the time is now for us to decide how to proceed on this matter. Any discussion on that point, colleagues?
Mr. Chair.
Please, Commissioner Thompson.
I think council raises an interesting point about the emergency thing here. So I would be interested to move this to investigation and see if that is flushed out in any way by our investigators.
Executive, any comments on what you heard today from the council? You or your investigators, please.
The idea of an emergency exception to the prohibited use of office, I don't know that really is in statute at all. I would point out, for example, in terms of falling, if she had been at work and fallen, asking someone at work to help you get up, I think wouldn't necessarily be use of office. But that is not what is before us. What is before us is she's home, she's off duty, she's in another location, and she falls. She isn't calling emergency services saying, I've fallen, can you send someone to help me get up, which does cost money. She's calling the college and saying, can you send someone over here to help me? And so I think there is a distinction between an emergency at work versus an emergency at home and using your position to get work to come help you.
Thank you. Any questions or comments, colleagues, from what you just heard from our executive? Any questions for our respondents? Okay, beyond what Commissioner Thompson has said, any other comments? Hearing and seeing none. Vice Chair, please.
Mr. Chair, I hereby move the commission find there is a substantial objective basis for believing that Colin Varick may have violated ORS 244-040 sub 4, ORS 244-040 sub 1, ORS 244-025 sub 1, and ORS 244-120 sub 1 sub C, and that the commission should investigate accordingly.
Colleagues, you've heard the motion. Any comments on it before we decide how to proceed and take a roll call vote? Hearing and seeing no comments at the moment, our administrator, pardon me, will please call the roll on item 2.7.
Commissioner Burke.
Aye.
Commissioner Burke. Thank you. Commissioner Thompson.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Jancy.
Aye.
Commissioner Mason.
Aye.
Commissioner McCully.
Aye.
Chair Fiscom.
Aye.
Motion passed 7-0.
Thank you, Mr. Slezak and Ms. Varick. We've decided to move ahead to conduct an investigation. You understand that's the next step in the process designed to get more information. Understand also that the words of our motion are very important. We have not found there to be in violation. We need more information before we make that decision. That said, thank you for your appearance today and for your patience with our agenda and for your clients' ability to show up online. We appreciate it. Thank you very much.
Thank you, Commissioner.
Thank you, Commission. Thank you, Commissioner.
Thank you. Okay, colleagues, in just a moment. Executive, do you want us to hear 25 and 26 and then move to the ones involving the others? Okay, we'll follow the order. Our approach now, colleagues, will be to hear items 25 and 26 together, even though eventually when the time comes, we will vote on those separately. Our executive is the investigator on these matters. items 25 and 26. Please proceed.
Thank you, Chair and Commission. This is Susan Myers, who at the time was acting as an investigator. Clearly, I really missed writing PR reports.
I figured you did.
So these are two separate ethics cases. They were both self-reported by two members of the Warrenton-Hammond School Board. And so initially, Board Member Crystal Green self-reported that she feared she had failed to disclose a conflict of interest when required to do so. And then about a week later, Board Member Tabitha McGroarty did the same. They both arose, the issue arose out of the same board meeting in July 16th. And what the school board was considering in that meeting was a memorandum of agreement with the Certified Teaching Employees Union, the WEA. And it was basically an agreement to extend the collective bargaining agreement for the Certified Employee Union to extend it by a year. It provided a 5% cost of living adjustment, a few tweaks and changes to the amounts that the district would cover in insurance, an adjustment to the sort of additional duty payments. The conflict of interest for the two board members arose because they each have relatives working at the district who were covered by the collective bargaining agreement at issue. And so when the board considered the memorandum of agreement in July, neither of them announced any conflict of interest, even though what they were voting on would have a certain financial impact on their relatives. And so they failed to announce a conflict. Once they realized and did their self-reports, they also asked the school board to put it back on the agenda for a revote at the August meeting. And at that meeting, they did announce, Crystal Green did announce a conflict of interest and abstained from the vote. Tabitha McGroarty, by the time of the August meeting, her relative was no longer covered by the CBA. And so she did not need to announce a conflict at that meeting. Now, all of that aside, so they took steps to correct and resolve the situation. The other matter that is discussed in my reports is, did they actually have a conflict of interest? Because the class exception in ORS 244020 sub 13B could arguably apply. And I know that we do not address the class exception as often as people think we do, and sometimes the commission has questions about it. I think these two cases were an opportunity to really explore. And so the class exception applies when there is an identifiable class of whom the public official or their relative is a member. And all members of that class would be affected to the same degree or proportionately by the actions being taken by the public official or the public body. So in this case, the action being taken was extending the CBA for certified employees and giving them a cost of living adjustment that would affect all of the certified employees to the same degree or proportionately. I double checked and made sure that neither of these board members saw anything in the CBA or the memorandum of agreement that would impact their relative any different than any other. So it is, of course, up to the commission to determine whether a class exception exists. We have issued the commission advisory opinion that was referenced in the reports back in, I don't know the number in front of me, but quite a few years ago, we issued an advisory opinion specifically addressing school board members and collective bargaining agreements and their relatives. And the commission in that opinion advised it did find a class and did find that the class exception would apply. Given all of that and the additional steps these two board members took to resolve it, my recommendation in the reports is to dismiss the complaints.
Thank you. Questions for our executive on either items 25 or 26, related as they are? Sure. Hearing and seeing none. Commissioner Thompson,
Do
please.
we know how big the class is in this case?
I don't know the numbers. It would be all certified teaching employees at the school district.
Okay, fair enough. Thank you.
We have a decision now before us. Let's focus on item 25. Looking for consensus here. Hearing and seeing no needs to make any comments. Vice Chair, please.
Mr. Chair, I move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Crystal Green has violated provisions of Oregon government ethics law or warrant further review, and that this complaint be dismissed.
Thank you. For the motion, any questions on it? Hearing and seeing none, the administrator will call the roll. Item 25, please.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Chair Fiscom.
Aye.
Motion passed 7-0.
Thank you, colleagues. Vice Chair, item 26.
Thank you, Mr. Chair. I move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Tabitha McGorty has violated provisions of Oregon government ethics law or warrant further review, and that this complaint be dismissed.
Thank you. For the motion, colleagues, administrator will call the roll. Item 26.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Chair Fiscom.
Aye.
Motion passed 7-0.
Okay, thank you, colleagues. Let me ask a question. Does anybody need a bio break? Before we forge through the end of the executive session agenda?
I would not say no.
There are some people who would not say no. We will declare the executive session to be in a brief recess for a quote bio break unquote. We're now in recess, please. Go. Ready? At the gavel, I am reinstating the executive session, which was recessed a moment ago. The same statutory provisions allowing us to meet in this way pertain. We're now going to move colleagues to consider in a way in batch items 29 through 33. We're not going to, and the following will be our approach. First, we'll consider item 30 separately involving Leah Silber. After that item is considered by us, we will consider the others in block. Am I right, investigator? Thank you very much. So we will now open the preliminary review hearing relative to item 30 involving Leah Silber from the city of River Grove. And my understanding is that she is going to appear by teams, and so we'll await her arrival. Yep.
You're good.
Hi, I'm here.
Leah Silber, can you hear me?
Yes, thank you so much.
We can see you too. Thank you. For the record, my name is Dave Fisco. I'm the chair of the commission. This is the time now set to consider the matter involving your case. Our approach, as you probably already know, will be first to hear a report from our investigator, to which I will now ask Investigator Gallagher to please proceed.
Yes, thank you, Chair Fiscum and Commissioners. This is Investigator Lion Gallagher for the record. Executive session agenda item 30 in your meeting books is a preliminary review report for Leah Silber, a city councilor for the city of River Grove. The complaint alleges that the City Council approved meeting minutes from the April 14th, 2025 meeting that contained multiple errors and omissions and failed to provide a true reflection of the meeting. Public meetings law requires governing bodies to provide for the recording of all meetings, either through audio, video, or digital recording, or the taking of written minutes. However, neither a full transcript nor a full recording of the meeting is required, except as otherwise provided by law. But the written minutes or recording must give a true reflection of the matters discussed and the views of participants. Therefore, if either the written minutes or a digital recording comply with the statutory requirements, the governing body has complied with the law. In this case, it appears the City Council used both a full recording of the April 14th meeting and took written summary minutes. Given this, even if the summary minutes did contain an error, the video recording contained the full meeting content. In summary, there does not appear to be a substantial objective basis to believe the City of River Grove City Council violated ORS 192.650. So the recommendation is to dismiss the complaint.
Thank you, investigator. Appreciate the report. Colleagues, any questions for our investigator before we proceed? For the moment, hearing and seeing none, Ms. Silber, welcome to the Ethics Commission today. This is the time set for you to make any comments you choose to make. Please do so for the record, and we may hold you to a fairly brief time limit in light of the length of our agenda. So thank you for being here. Please proceed.
Thank you, Chair, and thank you to Investigator Gallagher for the thorough review of the facts. The preliminary review confirmed what I documented, that the April 14th minutes contained material inaccuracies, including directly reversing a counselor's stated position. These facts are not in dispute. However, I respectfully suggest that the preliminary review focus too narrowly on whether technical compliance was achieved through the existence of video recordings rather than on addressing the core issue, whether a governing body can knowingly approve false written minutes. The preliminary review's interpretation that video recordings excuse inaccurate written minutes creates a troubling precedent. If this stands, it would effectively void ORS 192.650's requirements that minutes provide a true reflection. Why would the legislature require accurate minutes if they intend to allow false ones whenever video exists? This interpretation could undermine the clear purpose of the statute. On May 12th, as one of 5 city councilors with a responsibility to ensure the accuracy of our public records, I documented multiple material inaccuracies in our minutes. I had prepared detailed, easy-to-review documentation comparing the transcript to the minutes, formatted for quick verification. I offered this evidence and moved for unanimous consent to table the vote for review. The mayor explicitly objected to tabling, even though this is standard procedure when concerns are raised. No councilor even requested to see the documentation before voting. I respectfully ask you to consider what dismissing this concern would mean. A public official exercising their oversight responsibility says these public records are false. Here's the evidence. Let's verify before voting. The response is don't look at the evidence, don't verify, just vote yes anyway. The preliminary review has since confirmed the core inaccuracies that I identified were real, including directly reversing a counselor's position. Notably, many of these inaccuracies involved omitting or mischaracterizing statements about accountability concerns, the very oversight discussions that public minutes exist to preserve. There was no deadline, no urgency, just the refusal to spend even 5 minutes ensuring that the public record was accurate. The preliminary review's interpretation of this situation creates an untenable problem. It suggests that every citizen must now verify approved minutes against hours of video because the official written record might be false. Consider what accepting this interpretation really means. Any governing body with a camera could approve minutes documenting that all members voted yes when they voted no, or the body approved X when they rejected it, or no public comment was received when citizens spoke passionately. As long as video exists somewhere, the false written record would stand. The preliminary review cites no case law or precedent for this interpretation. ORS 192.650 explicitly states that the written minutes or recording must give a true reflection of the matters discussed at the meeting and the views of the participants. The legislature clearly foresaw that governing bodies might choose either method or both. Nothing in the statute suggests that having a recording licenses the creation of false written minutes. This interpretation would also create an absurd result in Oregon's statutory scheme. While ORS 162.305, which criminalizes knowingly making false entries in public records, is not within OGEC jurisdiction, the legislature could not have intended the interpretation of ORS 192.650 to permit conduct that another statute makes criminal. The opportunity here is to provide guidance on what ORS 192.650 requires, and that guidance should align with Oregon's broader legal framework. I cannot imagine that reversing a counselor's position from no to yes qualifies as a true reflection under even the most generous interpretation, and that's exactly what dismissing this case would permit. I'm asking the Commission to proceed with investigation because Oregon's governing bodies need clarity on a fundamental question. Can they knowingly approve false minutes simply because other records exist? The Council was explicitly warned that they would be violating ORS 192.650. I'll read briefly from the transcript. I said, I will remind us that we have specific legal and ethical obligations to make sure that the meeting minutes reflect the content of what happened, and these do not. There's ORS 192.650 if anybody wants to look it up. They chose to approve anyway. A letter of education would provide valuable guidance to all Oregon governing bodies that the existence of recordings does not license the creation of a false written record. This case asks a simple question, and answering it could help substantially clarify the legal and ethical obligations of public bodies across Oregon to not deliberately misrepresent the contents of their meetings. As such, I respectfully request that the Commission proceed with the investigation. Thank you for your consideration.
Thank you, Ms. Silber. Any colleagues, any questions for our respondent who has just made a few comments to us for the record? Looking for hands or anybody? I'll ask a question of our investigator or executive. Anything that was said in the last few moments suggest a comment from either or both of you?
Simply clarify that the public meetings law does not say anything about a governing body has to approve or adopt minutes. What it says is it has to take minutes or a recording or both, as we do. And so while, yes, ideally they would accord, there is a record of exactly what is said, and that's in the recording.
Thank you. Colleagues, how would you like to proceed? I'm open for discussion in light of what you've read and heard on this matter before us.
Sure.
Commissioner Thompson, please.
Well, I agree that our hands are somewhat tied here by statutory construction. I would be interested in hearing from the executive director or maybe our counsel about, rather than investigating this specific case and issuing a letter of education, should it come to that, is there a way that we can issue an advisory opinion on the subject of the minutes not matching the recording and what the advice of the commission would be at that point?
That's my question as well. You've well stated it so thank you. I'll associate myself with that question, executive.
Yeah, I would say one of two things in response to the advisory opinion thing, as was pointed out to me earlier this week. The commission has the authority to issue an commission advisory opinion responding to a request on public meetings law, not executive session. So when it's a public meetings law question, we would need to have a request. That your authority to issue an opinion without a request doesn't exist for all of public meetings law. But certainly Ms. Silver or someone else could submit a request and we could issue an opinion relative to, minutes versus recordings and what is required for either or both. The other thing I wanted to say is, as you know, we are going to request the Law Commission look at public meetings law as a whole, and this could be an issue that we bring up to them as needing to.
This could be an added addition or an addition to that discussion still pending. That's what I'm hearing you say. The general public meetings law rewrite issue, partial rewrite issue, pardon me. Thank you, counsel. Any additions to that comment? Thank you. Vice Chair, any other follow-up?
I think I would just ask that to Ms. Silber that rather than filing complaints in this matter, which I think our hands are tied on, I would ask that she ask us for an advisory opinion on this matter.
I agree with that. Thank you, colleagues. Any other comments, questions? I'll look to the Vice Chair to.
Chair, I'd just like to thank Ms. Silber for her thoughtful comments. Appreciate them.
Thank you, Commissioner Jancy. I appreciate it. I'm looking for your hand. I didn't see it, but thank you for your comments. Okay, Vice Chair, you want to make a motion, please?
And Becky gets to be my hero for the day because she gave me a much shorter motion to make on
Thank you very much.
So
Becky who?
Becky Mason, our illustrious. There's so many of them.
There's so many leaders. That's true.
All right. For executive session agenda item number 30, yes. I move the commission dismiss the complaint against Leah Silber.
Thank you. You've heard the motion, colleagues. This pertains to item number 30, and that individually, you've heard the motion to dismiss. Any questions or comments? Good discussion in the the motion, so thank you for your participation in that. Hearing and seeing no need for comments, the administrator will call the roll. Item 30.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Jancy.
Aye.
Commissioner Mason.
Aye.
Commissioner McCullough.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Chair Fiscum.
Aye.
Motion passed 7-0.
Thank you, colleagues. Ms. Silver, you've heard the result, but you've also heard the discussion. I saw your head nodding a few times, so we appreciate your participation today and the clarity of your comments. Proceed forward. Thank you very much.
Thank you.
Sure. Okay, colleagues, we will now turn, help me with this, Investigator Gallagher or somebody else who knows. We'll consider items 29, 31, 32, and 33 in the same order. Those individuals thereby mentioned, Mr. Chris Barheit, Kurt Taylor, William Tuttle, Doug McLean, are all scheduled to be on Teams to hear the report and make any comments they choose to make. So I'll wait for staff to tell me that we're ready.
Good to go.
Thank you.
Oh, and
Hello? Please.
Chair, Respondent Doug McLean may not be joining.
Okay. All right, thank you. So the time is now set to consider, for purposes of our agenda, items 29 through 33 involving the city of River Grove. Our process, gentlemen, if you're online, Chris Barheit, Kurt Taylor, William Tuttle, and perhaps Doug McLean. Can any of you acknowledge you can hear me?
I can hear you. This is William Tuttle.
Thank you. Any others?
Yeah, I can hear.
Thank you, Mr. Barheit. Appreciate it. I'll assume we're good to go. The process that we follow involves first, as you may already know, respondents a report from our investigator, whom I will call on right now, Investigator Gallagher, making a report on items 29 through 33, though we'll consider those in the end with votes individually. Investigator, please.
Yes, thank you, Chair Fiscum and Commissioners. This is Investigator Lion Gallagher for the record. Executive session agenda items 29 and 31 through 33. In your meeting books are preliminary review reports for members of the City Council of the City of River Grove. The complaint in this case alleges that the City Council approved meeting minutes from the April 14th, 2025 meeting that contained multiple errors and omissions and failed to provide a true reflection of the meeting. Public meetings law requires governing bodies to provide for the recording of all meetings, either through audio, video, or digital recording, or the taking of written minutes. However, a full transcript nor a full recording of the meeting is required, except as otherwise provided by law. But the written minutes or the recording must give a true reflection of the matters discussed and the views of the participants. Therefore, if either written minutes or digital recording comply with the statutory requirements, the governing body has complied with the law. In this case, it appears the City Council used both a full video recording of the April 14th meeting and took written summary minutes. Given this, even if the summary minutes did contain an error, the video recording contained the full meeting content. In summary, there does not appear to be a substantial objective basis to believe the City of River Grove City Council violated ORS 192.650. So the recommendation is to dismiss this complaint.
Thank you, Investigator. You've heard the report, colleagues. Any questions for our investigator based on her report that pertains to items 29, 31, 32, and 33? Hearing and seeing none, the time has now arrived for those respondents to make any comments to us they choose to make individually, recognizing that the recommendation from our investigator is to dismiss. I'll let any of you who choose to make any comment to us you choose to make. And if you make a comment, please do so with your name attached. Thank you.
Yes, this is William Tuttle, City Council President, River Grove. Councilor Silber was appointed in the summer of 2024 to fill a vacancy. She was not elected. She seemed to be a good candidate, has made some good contributions. Things went well for about 6 months, minutes were approved, etc., until about March of 2025. She has since filed at least 2 complaints with the Ethics Commission, which could and should have been resolved by council, thus using valuable commission time and resources. In the first instance, since adjudicated, I was angered that she cited 2 items that are supposed to be on our website, but never discussed these or mentioned it to the council. The second complaint currently being considered started with the May meeting and approval of minutes. Councilor Silber stated she had some objections to consider, although she had not provided a list beforehand. Knowing that it would take over an hour of council time to review them, we approved them with the following caveat. She is to provide her listing, which turned out to be 10 items, and we will consider them at the June meeting and correct the minutes as we feel necessary. The items were analyzed. The Ethics Commission has a copy, and I don't recall much input from Councilor Silber. One item was a misstatement of a position on the matter, and we admitted to that. Another was an error of omission, which could be valid, and the third was not including an outburst of a citizen. These were either opinions or wrong. She seems not to understand the composition of written minutes. The council has voted to have Zoom meeting as the official minutes and to provide a time-stamped summary so citizens do not have to listen to 2 or 3 hours of recording to find an item of interest. I sincerely hope Councilor Silber will try to resolve issues in council sessions rather than immediately going to the Ethics Commission, which in my opinion is not a good use of the Ethics Commission time and resource. There are 2 applicable philosophies that I have as a counselor. One, taken from interactions with HR. Don't tell me why I can't do something, tell me how I can. The other, regarding rules, regulations, ordinances, etc., is do not always take them literally, but consider their purpose and intent and act accordingly. Thank you for your consideration.
Mr. Tuttle, you quit your remarks, stopped your remarks within just the time frame. So thank you. Any other comments, respondents? Hearing and seeing none. Who?
Chris Barley.
Mr.
No, I
Barhide,
was
did
just
you
gonna
want
say,
to?
no, I have no comments. That's all I was
Thank you.
saying.
Thank you very much.
Can you hear me? This is,
Okay, colleagues.
can you hear me? This is Kurt. This is
Who's
Kurt
speaking,
Taylor. I have
please?
no comments either.
Thank
Kurt
you very
Taylor.
much. I appreciate it. Thank you.
I have no comments and support Mr. Tuttle's remarks wholeheartedly.
Thank you. Appreciate it. Okay, commissioners, the time now comes for us to decide how to proceed on the matter before us, and we will proceed through these matters before us individually. The first item is that they have the same dynamics associated with all of them. So I'm interested in how you'd like to proceed. Hearing no comments, I will assume a motion is in order. Item 29, please.
Thank you, Mr. Chair. For executive session, item number 29, I move the commission dismiss the complaint against Chris Barhide.
You've heard the motion, colleagues. Any comments? Hearing and seeing none. Administrator will call the roll. Item 29.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Chair Fiscum.
Aye.
Motion passed 7-0.
Thank you. We'll now move, colleagues, item 31, same dynamic, same set of pieces of information involved. Vice Chair, please. Item 30.
Mr. Chair, I move let me start again. Mr. Chair, for executive session, item number 30, I move the commission dismiss the complaint against Kurt Taylor.
It's item 31.
31.
31.
Scratch that. We're going to start for a third time.
Vice Chair, please make a motion.
For executive session item number 31, I move the commission dismiss the complaint against Kurt Taylor.
Thank you, Vice Chair. I think
we're not sure it's good yet.
Colleagues, you've heard the motion. This is item 31 on your schedule. Hearing and seeing the need for no discussion, the administrator will call the roll. Item 31.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Fiscum.
Aye.
Motion passed 7-0.
You colleagues will now move to item 3.2. Vice Chair, please.
Chair, for executive session item number 32, I move the commission dismiss the complaint against William Tuttle.
For the motion, colleagues, seeing the need for no discussion, the administrator will call the roll. Item 3.2.
Commissioner McCully,
Aye.
Commissioner Mason,
Aye.
Commissioner Jancy,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Fiscum.
Aye.
Motion passed 7-0.
Moving on to item 3.3, executive session calendar. Vice Chair, please. Item 3.3.
Mr. Chair, for executive session agenda item number 33, I move the commission dismiss the complaint against Doug McLean.
Colleagues, you've heard the motion. Seeing a need for no discussion, the administrator will call the roll. Item 3.3.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Chair Fiscum.
Aye.
Motion passed 7-0.
Thank you. That means that, we done 33 yet? We did just did 31. Thank you. So that means that all of these issues involving the city of River Grove have been individually dismissed. Thank you, respondents, for appearing before us today online or by Teams. We appreciate that. And these items have in fact been dismissed. Mr. Barheit, please stay online. Then another item involving your name will be coming up next. So just stay online while our staff otherwise takes action to exit folks from the room. Thank you for being here this morning. And it's still morning. Thank you. Good to go? Yes. Okay, colleagues, the time is now to consider item 2.8 on our agenda involving Mr. Chris Barheit from the city of River Grove. Our process is to hear a report from our investigator first. Investigator Pacheco, please.
Thank you, Chair Fiscum and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 28 in your meeting book is a preliminary review report for Chris Barheit, Mayor for the city of River Grove. The complaint in this matter arises from a previous public meeting law complaint filed against Mr. Barheit and other members of the city council. Due to their size and limited resources, the city does not have an on-call attorney and contracts for their legal services. The complainant alleges that at the April 14, 2025 City Council meeting, Mr. Barheit used his official position for financial gain when voting to approve that the city attorney respond to the PML complaints that had been filed against him and other members of the City Council. As provided in Staff Advisory Opinion 23-156S, which addressed the question of whether a public official can use their city attorney on an ethics-related matter, the opinion provided that if authorized by the city, a city attorney may provide a statement on behalf of the city rather than on the public official's behalf. Based on the information gathered, because Mr. Barheit made a motion that would authorize the city attorney to respond to the PML complaints on behalf of the City Council, of which he is a member of, rather than the city as a government entity, it appears that he violated the prohibited use of office provision. In this case, the opportunity to make a motion and vote was only available to him because of his official position on the City Council. Additionally, it appears that his actions at the April 14th meeting also resulted in an actual conflict of interest, which he failed to announce and abstain from voting as required per ORS 244.120 sub 2. Commission staff separately note that ORS 244.390 sub 2 provides that before finding cause to undertake an investigation, the Commission shall consider the public interest and any other penalty or sanction that has been or may be imposed on the public official. In this case, there was no information to suggest that Mr. Barheit hired the city attorney to represent him on his own PML complaint. And notably, all of the work done, including the billable hours by the city attorney in response to the PML complaint, was done on behalf of the city of River Grove. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Chris Barheit violated ORS 244.040 sub 1 and ORS 244.120 sub 2. The recommendation in your books is to move this case to investigation. Thank you.
Thank you, investigator. Any questions for our investigator based on what you've just heard, colleagues? Hearing and seeing none, Mr. Barheit, thank you for staying online with us. This is your time to make any comments you choose to make to us. Please do so. And just for the record, I will hold you to a bit of a time limit on this. So please be concise and straightforward. Thank you for being here today.
Yeah, thank you, Chair and Commissioners. Slightly frustrated, I guess, with this complaint. We received the first ethics complaint from a fellow counselor and received a notice from an investigator, which is a little scary as a volunteer to get something from it as an official investigation. So we don't have counsel on staff. So if we were the city of Lake Oswego, Portland, Beaverton, Tualatin, we would have asked our counsel, what does this really mean, since we didn't know. Instead, I went to the council and asked if we should use, spend money, because we have about $47,000 budget. If we could spend money to talk to our city attorney to ask them how to proceed. City attorney gave us advice that they could only reply for the city as a whole, as a body, and exactly what happened. So if you read the letter that was sent, it is in regards to the process that we had on that first initial complaint on how we do public notice to meetings. So we voted on that in the meeting. Everyone voted. We talked about it in a public meeting. We had the attorney write the letter. I think if you read the letter, it's pretty clear that the letter is, as the investigator said, is in regards to the whole city. So I guess my frustration is that I feel that we have a counselor on our city that's using the ethics board as a kind of weaponizing it, to be honest. Any other city would have had the opportunity to talk to an in-house counsel and resolve all these matters in-house. There was no, I don't feel that I have any benefit. I mean, we were trying to just do what's right for the city. And I feel like we just have somebody that's using the hard work of this commission to weaponize against when they don't get what they want in a meeting. They're using every agency in the state of Oregon against their own counsel. I think you saw that from the last case with Counselor Tuttle, who had been on council for 20 years and doing our minutes. Same kind of thing. The first one, he referenced the first one. We just, every time she thinks we do something wrong, she goes right to your commission or Department of Justice, or we have a thing with ODOT she's gone to, and she's using these cases in those notices when she doesn't get her way and says we have ethics complaints against us. It's just crazy. It's a shame she's using the hard work and the good people of this commission to weaponize against us when we're trying to do what's right. So I would encourage you to dismiss the case.
Thank you, Mr. Barhide. Appreciate your comments and for your patience with our agenda today. Any questions for Mr. Barhide in light of his comments in the last few moments, colleagues? Okay, the time is now for us to discuss, if we have discussion about how to proceed before we vote. I'm interested in anybody who has any comments to make in light of what you've heard and what you've read. Executives, please.
We had an active discussion as to what the recommendation should be. And I want to clarify, lots of cities in similar situations or city attorneys have acts, like when they get a complaint, they're like, oh, well, we want to respond. And so typically what happens is when they start reaching out to us, we will provide a copy of that staff advisory opinion in case they are not aware. And that advisory opinion does explain sort of the distinction to protect people from potential ethics violations. The distinction is important that the city attorney can respond, can provide information on behalf of the city, but can only represent them as their attorneys if they are otherwise, if there's something in their official compensation package, if they have a policy or something in the contract that says the city attorney is authorized to do so. The dilemma here is the timing of, at the time they made the vote, the motion was to have the city attorney respond on their behalf, not on behalf of the city, on behalf of the council. Now, it does appear, as I think Daniel explained, that in the report that when they made the motion, someone brought up the issue and they did sort of attempt to address it at that time by asking the city attorney to clarify. And certainly by the time the letter was submitted and we had provided the opinion to them, he did submit the letter on behalf of the city. So really here it was a timing issue.
Thank you. Questions? Just a second, Mr. Barhide. I want to make sure there are no follow-up questions to what our executive just said. I've got a comment or two in a minute, but I'll yield to you, Mr. Barhide, for a quick response, please.
Yeah, I guess my point was summarized by your executive director is in most cities, the attorney would review that prior to, we don't have an attorney. That's our problem. So we as a city, in most cities, the attorney would probably write the motion. We're unable to have that. It's really an unfortunate situation for a small city. So maybe we made a clerical error. There was no intent since and I was on the city council for City of Tualatin. We had an in-house staff member for an attorney. They wrote our motions a lot of times, and like we would have things in our agenda that said, here's your motion. This is what it's going to be. We don't have that. So we're doing it on the fly without legal advice. This was trying to say, look, let's spend some money to get legal advice on how this needs to happen. And I feel like we're being punished when every other city or commission has that legal advice at their ready and can guide them through the process. We don't have that. And this is an unfortunate situation that we'd be punished for.
Thank you, Mr. Barhide. A couple, three comments. First of all, Executive, I was interested in your commentary that this was an internal debate you had about how to proceed on this matter. Summarize that for me, if you would. Both sides of that, no doubt friendly debate.
Yeah, I mean, in favor of a motion to dismiss is the fact that by the time any actual action involving us took place, by the time they submitted the letter, they had figured out that the city attorney that they hired could not respond on their behalf, that they had gotten the staff advisory opinion. In favor of a motion to move to investigation, which would inevitably lead to, at most, a letter of education. But in favor of that is at the time of the vote. At the time they made the motion was to hire an attorney to provide a response on behalf of them. So under the use of office statute, it is at the time they made the motion, were they using their positions to avoid personal financial detriment?
Thank you. Second comment for me is it would be possible for me to contend that in this matter, up to this point, education has in fact occurred. If that's one of our goals under our still to be redrafted mission statement, we have seen that education folks have been educated to the process they need to follow in the future. So education has occurred. And the third comment is one that may not have much legal standing, with all due respect to our counsel. This issue doesn't strike me as one that rises to the status of a real ethics issue worth our time in light of the process that's gone forward. So all of that said, my notion, subject to colleagues' participation and discussion, is to head toward dismissal. Comments? Vice Chair, please.
I agree with the chair on this one. I think this council did what they were supposed to do. They reached out to their attorney to get advice on how to proceed. Whether the motion was exactly accurate.
And we lost him?
They're still on. It's just.
Oh, here it is. Thank you.
Whether the motion was exactly accurate. I mean, I don't know that we want to get into from this commission of arguing over the specific wording of motions. Well, I'll leave that for someone else. But I think they had a problem. They made a motion to ask their attorney about their problem, which they did, and I think we should encourage that. So I'm in favor of dismissing this complaint.
Any other comments, colleagues, before I turn to our vice chair for a motion? Hearing and seeing none, Vice Chair, please make a motion.
Mr. Chair, for executive session item number 28, I move the commission dismiss the complaint against Chris Barhide.
You've heard the motion, colleagues, and discussion on the motion. Hearing and seeing none, the administrator will call the roll. Item 2.8.
Commissioner Thompson.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner Jancy.
Aye.
Commissioner Mason.
Aye.
Commissioner McCulley.
Aye.
Commissioner Burke.
Aye.
Chair Fiscum.
You and me. Whoa, that's a yes vote.
Motion passed 7-0.
Excuses for yes, one no.
I apologize for my performance, colleagues. You've heard the motion to dismiss. Mr. Barhide, thank you for your patience today with our schedule and for your comments. We appreciate it. You've heard the result.
Thank you very much. And hopefully I don't have to see you again.
Keep doing good work. Nice to see you too.
Yeah. All right. Well, thank you, everybody. Have a nice day and weekend.
Thank you. Thank you, Mr. Barhide.
All right. Thank you.
Okay, colleagues, we'll follow through now and consider item 2.3 back on your agenda a ways involving Mr. Jeff Gowing, if I'm saying that right. So look back on your agenda for item 2.3 starts on page 7-9. Mr. Gowing is intending to be on the phone. Is he on the phone yet, or do you know?
Getting him pulled up.
Thank you very much. Thank you for the cough drop and the water. I appreciate it.
You're welcome, Chair.
All further contributions accepted.
We are.
Sorry. Mr. Gowing, can you hear me? Mr. Gowing, you may be on mute. Press *6 and to go off mute.
Can you hear me?
Mr. Gowing, speak up just a little bit. Can you hear me?
Yes, can you hear me?
Thank you. We can now. Thank you very much, Mr. Gowing. This is Dave Fiscum, Chair of the Commission. The item is now set to consider the item involving you and the Lane County School District. Our process, as you may be aware, is to hear a report from our investigator. So we will do that now, and then we'll proceed to let you make any comment you choose to make to us. We'll start with Investigator Fenstermaker, please.
Thank you, Chair Fiscum. Commissioners, I'm Casey Fenstermaker. Agenda item 23 is a preliminary review report regarding Jeff Gowing. The complaint in this case alleged that Jeff Gowing, formerly a Lane County School District 45J3 school board member, failed to announce conflict of interest during the school district's budget committee meetings and during the school board meeting at which the budget was adopted. Information reviewed during the preliminary review indicates that Jeff Gowing's wife is the financial director at the school district. As an employee of the school district, Jeff Gowing's wife's salary was included in the school district's budget. As a result, it appears that Jeff Gowing was required to declare a conflict of interest and refrain from participating in the discussion and voting on the budget because he was taking an action which would result in a financial benefit to his spouse. If this case is moved to investigation, however, commission staff will review whether or not there is a class exception that applies. Based on the information reviewed during the preliminary review phase, the recommendation is to move this case to investigation.
Thank you, investigator. Any questions for our investigator colleagues? Hearing and seeing none, Mr. Gowing, the time is now for you to make any comments to us. You choose to make two things. One, when you make comments, please identify yourself for the record. And secondly, I may hold you to a 3-minute time limit so be precise in what you want to say to us in light of this matter before us. Thank you for your attendance today. Please proceed.
Thank you. Thank you. My name is Jeff Gowing, and I am a former board member and did vote on the budget and at the budget meeting and the budget. I did so from advice. I didn't declare because a conflict because I was told by district staff and ASBO I did not need to because my wife's salary is the budget as a whole, not her. It wasn't voting on hers individually. And there was two other board members. One, his spouse and his son were bus drivers, and another board member, his son and daughter-in-law are school teachers. So I didn't think that, if they didn't need to, that I didn't need to either. So I guess that's about all I got to say. I didn't do it intentionally. It was all in, I thought everything was okay. The person that filed the complaint against me absolutely hates me, and so I figured that's why I got targeted.
Thank you, sir, for your comments and your attendance today. Any questions for Mr. Gowing based on what he's just said? The time now rises, colleagues, for us to decide to discuss how to move ahead on this matter and to discuss that. So I'm looking for any comments that anybody chooses to make to us, colleague commissioners, on the matter involving the matter before us in number 23, Mr. Jeff Gowing. Any questions, comments? I guess the part question I have is Mr. Gowing has said that he didn't vote on his individual relative salary. He voted on a larger item that included that salary as opposed to a specific item for that salary. If I've said that improperly, correct my record, and then executive, please respond.
So, no, you said it properly. The question is, in voting on the budget, whether there's a specific line item for him individually or his spouse, or whether it's simply that salary for his spouse is included in the overall budget that they are voting to approve, he would have the same conflict of interest. He is voting to approve a budget that includes his spouse's salary. Now, as the commission may recall, in the last legislative session, Senate Bill 983 was passed. It didn't go into effect until near the end of June. And so Senate Bill 983, we did work with the Oregon School Board Association to get that passed. And it specifically provides that a member of a governing body can vote on a budget that includes their own compensation or that of a relative, so long as before doing so, they announce their conflict of interest, the nature of their conflict of interest. The problem here is that statute was not yet in effect.
Further, if Mr. Gowing would have enunciated a conflict of interest in this matter, albeit a large budget that included his relative salary, that would have met the test of the law at the time. Is that accurate?
He would have needed to announce and refrain from participation unless the minimum vote, because it would be an actual conflict. If it happened after the new law went into effect, he could have simply announced and then he could have voted.
Thank you for that distinction. I appreciate it. Colleagues, any questions or comments from our executive, or I guess for me? How would you like to, okay, hearing and seeing no comments, how would you like to proceed on this matter? Open to suggestions and or a motion. Vice Chair, do you have any comments or a motion?
I feel like the law's been changed. He's a former school board member. He's been educated. I think we've done our job here.
Well, that happens to be my view without absolving anybody from a responsibility they otherwise would have had. It seems to me that this is a fairly, my word, small issue that doesn't rise to the level of a major ethics issue for our consideration. I understand the distinction that could have been in place in the gentleman's mind at the time about a big budget and a small piece for a relative. Yeah, so I guess education to, maybe you, Commissioner Thompson, education has occurred. Colleagues, please argue with me or anybody else you want to argue with. Vice Chair, oh, pardon me, Commissioner Gutierrez, please.
Thank you. I just wanted to add that I agree with the comments that you and the acting vice chair made.
Thank you, sir. Appreciate it. And Commissioner Mason, please.
I agree with the chair.
Thank you. Any other comments, colleagues? For the moment, hearing and seeing none, Commissioner Thompson, please.
Mr. Chair, for executive session item number 23, I move the commission dismiss the complaint against Jeff Gowing.
Thank you. You've heard the motion, colleagues. Any questions on it? At the moment, hearing and seeing none, the administrator will call the roll on our executive session agenda item 2-3.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Fiscum.
Aye.
Motion passed 7-0.
Thank you, colleagues. Mr. Gowing, this matter, if you can still hear me, has been dismissed. Thank you for your patience with our agenda today, and thank you for your comments. We appreciate it. Have a nice weekend. She's gone. No problem.
Yes, for an answer.
Okay, colleagues, we're now going to proceed to the last item. Colleague, questions?
Is it clear? Oh, thank you.
Okay, thank you. We'll now proceed to the last couple items on our executive